Representative Reimer, welcome to the committee to present HF3101, and your testifiers can be joining you at the table. So on behalf of Representative Reimer, I move the bill, and our intention is to send this on to the Judiciary Committee. Representative Meyer, please state your name and present your bill.
Madam Chair, that is what I'd like to do with the bill. My name is Max Reimer. Thank you all for joining us here. Thank you, Chair and Co-Chair Wolgamott, for the opportunity to present House File 3101. I want to keep my remarks brief because we have a lot of good supporting testimony for why this bill is necessary. House File 3101 creates an Intellectual Freedom Protection Act, which creates a viewpoint neutrality at our public post-secondary institutions. This bill is based on the simple principle public colleges and universities shouldn't require students or faculty to adopt specific political or ideological beliefs as a condition of admission, employment, promotion, or access to benefits. Because they are public institutions, these are government actors, and the government shouldn't be in a position of compelling speech or ideological statements. To be clear about what this bill doesn't do, it doesn't prohibit diversity, equity, or inclusion programs, and it doesn't restrict what can be actually taught in the classroom. There's a transparency component to this bill as well as an enforcement mechanism to this bill. I'm happy to answer any questions about this bill, but I do want to leave time for my testifiers today. So thank you for your consideration.
Thank you, Representative Reimer. First up, we have Tyler Coward. Please come and state your name for the record. You have 2 minutes.
Hi, thank you, Madam Chair, members of the committee. My name is Tyler Coward. I'm lead counsel for government affairs at the Foundation for Individual Rights and Expression, or FIRE. We are a nonpartisan nonprofit organization dedicated to protecting the free speech rights of all Americans. And we rise today in support of HF 3101. Fostering a welcoming, discrimination-free environment in our colleges and universities helps students of all backgrounds have the chance to succeed. Academic institutions across the country have given this as their reason for investing millions of dollars in diversity, equity, and inclusion, or DEI programs. Unfortunately, some of these DEI offices have too often strayed from this noble purpose by inappropriately injecting themselves and their political perspectives into discussions of curriculum, as well as faculty hiring, reappointment, evaluation, promotion, or tenure decisions. No matter how well-intentioned, these ideological impositions on critical aspects of higher education are a step too far and often undermine the very goals they seek to accomplish. And across the country, a lot of universities have adopted mandatory DEI statements. The typical DEI statement policy is not concerned merely with the faculty members' relevant scholarship or the laudable goal of ensuring faculty remain free from that faculty do not discriminate in their work toward the success of all students, regardless of their identity. Many policies invade faculty members' freedom of conscience, prying into their private beliefs on matters of public concern. They compel faculty to express or demonstrate commitment to the university's viewpoints or to conform their pedagogy, research, or services to specific ideological perspectives. For instance, at Texas Tech University, public records revealed that biology department adopted a policy to require and strongly weight diversity statements from all candidates, resulting in numerous instances in which candidates were screened before even being evaluated on their competencies about biology, whether or not they had a statement that was sufficiently diverse. One candidate's evaluation notes that he mentioned DEI is not an issue because he respects his students and treats them all equally.
Thank you, Mr. Coward. We need you to wrap it up.
Okay, this was a long testimony, so I'll just say that when used at public universities, these DEI statements are constitutionally dubious at best. There's a long line of Supreme Court case law, including West Virginia versus Barnett, which prohibits compelled speech. In academic freedom cases, including Sweezy versus New Hampshire, that says that the essentiality of freedom in the American community of American universities is almost self-evident. No one should underestimate the vital role in a democracy that is played by those who guide and train our youth. to impose any straitjacket upon the intellectual leaders in our colleges and universities would imperil the future of the nation.
Thank you. Next, we'll go to Colleen Lindgren.
Thank you, Madam Chair. Mr. Chair, members of the committee, my name is Colleen Lindgren. I'm a Senior State Policy Manager for the Pacific Legal Foundation, and we're a nonprofit public interest law firm that represents clients free of charge around the country in a variety of constitutional cases, including cases dealing with equality under the law and the 14th Amendment. And we're devoted to dismantling unconstitutional barriers to opportunity and upholding the promise of the 14th Amendment. And in respect of time, I'm going to keep my remark very short because I want my colleague to be able to speak about an issue that came up here in Minnesota recently. But I'll just say that we have a long history of challenging the constitutionality of laws that include gender or race-based classifications in things like public contracting or school admissions or appointments to public boards, because these classifications perpetuate stereotypes and reduce individuals to mere groups. And so we're really grateful for you considering House File 3101 and for Representative Reimer to bringing this bill. We believe it promotes equality by ensuring students, employees, and other individuals are not required by institutions of higher education to espouse or adhere to certain viewpoints about others based on immutable characteristics. This is unconstitutional, and Minnesota is not alone in taking steps to protect against this. In the letter that we submitted, we listed states. There are 11 states since California kind of kicked off this trend, so to speak, in 1996. There are 11 states that have introduced various similar reforms, and this reform is also in line with stipulations that the state of Minnesota made in a recent case that we litigated on behalf of an individual here. And so I'd like to give the rest of my time to my colleague Brandon to discuss that.
Welcome to the committee. Please state your name for the record.
Thank you, Madam Chair and members of the committee. My name is Brandon Byer, and I'm an attorney for Pacific Legal Foundation. The 14th Amendment's Equal Protection Clause requires that the government treat citizens as individuals, not as mere components of racial or ideological class. The Supreme Court recently reaffirmed this in Students for Fair Admission v. Harvard when they said eliminating discrimination means eliminating all of it. This bill before you codifies that well-established precedent by ensuring that admissions to or employment at Minnesota's public institutions isn't conditioned on ideological pledges or racial or ethnic identities. Kylene mentioned it. In 2024, we filed suit to challenge a Minnesota law that imposed a racial quota for the Board of Social Work in the state. That law, which is still on the books, requires at least 5 board members to be from a community of color, effectively disqualifying qualified Minnesotans based solely on their skin color. In April of 2025, the District Court of Minnesota favorably dismissed that case after the governor jointly stipulated with us that he may not consider race or limit the pool of qualified applicants for appointments. The governor has acknowledged that these race-based requirements are violative of state and federal law, including the Equal Protection Clause. This bill before you simply brings our higher education institutions into alignment with this established precedent. Public service on higher education should be open to all qualified citizens based on their individual merit, not their adherence to a specific ideology or their immutable characteristics. We urge the committee to support this bill to protect intellectual freedom and equality for all Minnesotans. Thank you for your time. We're happy to answer any questions you have.
Thank you. We'll now move to member discussion. Great. Chair Noor.
Thank you, Madam Chair. To the author of the bill, the question is because we understand from research that individuals who benefit from having someone from the same background will help them succeed in higher education, for example. Will this bill limit that ability to have that freedom of having individuals who are going to be able to help particularly minority community to succeed in higher education? Will this bill prohibit those hiring practices?
Representative Reimer.
Madam Chair, Representative Noor, thank you for the question. No, I don't think so, because ultimately, when you determine hiring based on merit, I would assume if there's specific cultural pockets that we want to focus on in the university system, I would want to hire the person who has the most experience in that specific group. It's less about a racial quota and more about what kind of experience do you have in this maybe cultural arena.
Chair Noor.
Thank you, Madam Chair. Sometimes we have biases in the system. So when somebody uses their biases and excludes individuals specifically because they are not favorable to them, regardless of their, the merit system that exists, will that be looked into? Because this bill does not protect that for those individuals who may be excluded because of biases.
Representative Reimer.
Madam Chair, Representative Noor, I think this bill actually protects against bias. That's the whole point of the bill. So if there's inherent bias, and it could be, right, in a hiring situation, it could be that somebody might favor a specific ideology or a specific way of thinking. I think that this bill protects against the very thing that you're talking about.
Thank you. Are you done, Chair Noor? Thank you. Representative Coulter.
Excuse me. Thank you, Madam Chair. Representative Reimer, as you know, we also as a state publicly subsidize to a pretty significant extent private colleges and universities. Why does this bill not apply to them?
Representative Reimer.
Thank you, Chair and Representative Coulter, because it's a public institution. It's essentially an arm of the government. We don't have private schools approaching in bonding committee asking for $200 million on a yearly basis from the state of Minnesota. It's essentially an arm of what we just had a conversation about regents. We literally determine the leadership of our public institutions here at the state legislature based on the last debate, kind of, I guess, you know, but it's a public institution versus a private institution.
Thank you. Anything else? Yes, Representative Coulter.
So no, the private colleges are not asking us for bonding dollars, but they sure are asking us for state grant dollars. We spend quite a lot of money from the state grant going to private colleges and universities, both for-profit and nonprofit, I should add. So I think it's just curious to me that this doesn't apply to private colleges. Thank you.
Thank you. And I would note for the record that the state grant goes to students, not to institutions. Chair Wolgamott.
Thank you, Madam Chair. I just wanted to request a roll call vote on this motion.
A roll call has been requested and granted. So if there's no further discussion,
Sorry.
oh, I'm sorry, who? Oh, I'm sorry, Representative Hansen.
Thank you, Chair. I had to step out, so thank you so much. I did hear Representative Coulter's question, and I just kind of wanted to, I know I heard your response to, Chair, but I think we have to be honest that it goes to the student, but the student is giving that money to the institution, and so I just want to be really clear about that. It does go to, they do benefit from it, and we absolutely have people from private places coming forward and asking for funds. Welcome to the Higher Education Committee, Representative Reimer. This is a pretty hot topic you just broached into here. But that is a highly contentious statement to say that they don't approach us for money. We are looking at a lot of institutions that need assistance. Our private colleges are valued institutions here, and there's a lot of conversation about how we do continue to support them. But I do agree that with this, and you may not know this, our committee does, but I've had a very personal experience at a private college here in Minnesota that is a religious college, and that very clearly, your bill should apply to them. You should hear my story sometime, because I was not allowed to continue going to the college because of who I am, right? And so I would encourage you to maybe broaden the stakeholder base you might be talking to. I know folks in my queer community, we would love to talk to you about how this impacts us. And so I hope those conversations continue and that the perspective broadens a little bit. Thank you.
Thank you.
Madam Chair, if I may.
Representative Reimer.
I just want to make a clear distinction, and Representative Hansen, thanks for the comments. Because a student gets grant dollars or because there are PSEO credits, that does not entitle the state to be shareholders in a private institution. There are clear boundaries between what constitutes a public institution and what constitutes a private institution.
Thank you. So members, I renew my motion that HF3101 be sent to the Judiciary Committee. A roll call has been requested. The clerk will take the roll.
Chair Robbins.
Aye.
Chair Wolgamott.
Wolgamott votes no.
Vice Chair Schwartz. Vice Chair Coulter.
No.
Representative Allen.
Allen votes aye.
Representative Duran. Yes. Representative Hansen.
No.
Representative Hicks. No. Representative Cleburne.
Cleburne, no.
Representative Liebling.
No.
Representative Noor.
No.
Representative Novotny. Representative Rarick.
Aye.
Representative Scott.
There being 7 ayes and 7 nays, the motion does not prevail, and we will be laying HF3101 over. Thank you.